seated. We'll hear argument in case number 240053, Morrison versus Morrison.
May it please the court, Ms. Wright will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court. It is well recognized in Texas's jurisprudence that parties are generally free to contract as they see fit. Divorcing parties also resolve their differences via settlement as opposed to trial. The question here, the reason we're here, is to ask the court's assistance in determining whether the divorcing parties may receive the same or enjoy the same freedom of contract as other litigants. In this case, it's whether they can be free to confidently contract between themselves to resolve their marital dissolution as they see fit, and whether once they reach those agreements, the trial court may thereafter enforce those agreements via enforcement proceedings under Chapter 9 of the Family Code.
Could they agree by contract to allow the family court judge to assess different amounts of a division of property based upon future conduct of the parties?
Could they I believe, if I understand the question right, Your Honor, is whether they can agree to confer jurisdiction.
Yeah, but by contract, sort of say, look, we're going to let the trial judge, we're going to see how we both behave over the next 5 years, and we're going to agree by contract that the trial judge is going to have the authority to award us different amounts of community property based upon his assessment of our post-divorce conduct towards each other.
No, Your Honor, I don't believe that they can.
So where's the line then? Because that seems like freedom of contract too. We're agreeing to allow ourselves to be bound in a particular way, and there will be consequences. The consequences will be committed to the discretion of a district judge. If you're right, there must be some line somewhere if that is not permissible. And I think you're saying it's not, right?
I believe that Your Honor is correct. That is holding open a judgment as opposed to making it final. That also ignores the fact that once parties are divorced, their property is their separate property. However,
but is the difference that you're stating, because that really, I think that response would apply to all of this. But you're saying if you hold up the issue specifically about how much a property's worth, is that what we're talking about? That would be the difference? Is that what you're saying? In terms of what would not be allowable? In answer to Justice Young's question, I think.
I believe, Your Honor, the distinction here, and it may address both of the questions, is whether or not the matter becomes the subject of what needs to be an enforcement proceeding. In other words, the In re WLW case dealt more with how property was valued and whether or not that property should be re-evaluated because it was technically considered, according to petitioner, whether it was considered undisclosed or undervalued. Those things could have been determined by the court and by the parties as of the date of divorce. And those were peculiar facts in that case, but the husband put all of the values on his spreadsheet. The wife said unknown, undetermined, but she could have learned those facts. The difference here, and why this case more aligns with the Brady case, is because and I'll call him Rodney, I refer to him in our pleadings as Debbie and Rodney, had Rodney done what he agreed to do as of the date of filing for divorce, there would never have been a need for an enforcement. But because of the egregiousness of the conduct which occurred during the divorce, these parties bargained for what I'll call a liquidated damages provision. If any of the property which was to be sold, conveyed to the receiver, was damaged or destroyed, then there was a liquidated damage provision, and these parties contracted for it, they agreed to it, and it came to fruition. It became necessary to enforce that provision because Rodney's conduct made it impossible to carry out the underlying terms of the divorce decree.
So let's say if we were to agree that the parties can agree that you're to get this property worth $500,000, you're to get this property worth $500,000, but if you don't turn over this property that's worth $500,000, or let's say it's a brokerage account and now it's gone, then this property, which is worth $500,000, will be awarded to the other party. Let's say if that's okay. But you seem to be saying that if, however, the parties agreed that you're to turn over this amount, this $500,000 in a brokerage account, and if you don't do it, then the court is going to have the ability to reevaluate what the values were of these things, and that's not acceptable. And so is that what you're saying? And so can you articulate what that line is as far as
Maybe I didn't articulate. I don't think in any circumstance the court goes back and revalues the properties.
That's what I'm saying. That's what I thought you
I
said.
think that, and what these parties bargained for was if there was a set amount, if this or this or this is destroyed, it's at the fair market value of the asset. But what maybe isn't clear in the record is those assets were already valued. They had to be conveyed in the exact same situation they were in as of the date of the separation of the parties. And we had a fair market value of the house and the shop because both of those sold. I don't think it leaves it open for the trial court to go back and revalue. Well, what is this house worth now? What was it worth then? I don't think that's
But because of the provision in the decree, you think it does, the decree does leave open the ability to redivide?
I don't think it leaves open the ability to redivide, or I don't think it should, but I do believe it leaves open the ability. If this provision had never been included in these parties' decree, Debbie could have gone to the court and sought an enforcement for Rodney's 39 violations. The trial court could have determined, as it did, that awarding that property was an impossibility because it didn't exist anymore.
Right, and so say we agree with you that the Court of Appeals erred in concluding that the trial judge lacked jurisdiction over the motion to enforce.
Yes.
The trial court had jurisdiction over the enforcement action.
Correct.
But if you look at section 9.007, it says the title is limitation on power of court to enforce, right?
Yes, Your Honor.
So though the court has jurisdiction to enforce and can award damages in connection, actual damages, in connection with violations of the decree, why wouldn't 9.007 limit the power of the court to penalize by reallocating property pursuant to the decree? In other words, why wouldn't the remedy be prove up your actual damages associated with these violations, rather than just going in and saying, okay, Judge, we've decided that the whole thing gets reallocated if there's a violation?
The problem, Your Honor, is that, and particularly in this instance, it would have been virtually impossible to prove exactly what the actual damages are.
Well, I mean, to Justice Lerman's question, if the brokerage account now has $0 in it and it was supposed to be conveyed, you would be able to prove those damages. If it's a piece of personal property and it's been damaged or destroyed, you'd have that valuation that you say the parties made at the time of judgment. So you'd be able to prove that property is lost and gone, and then reduce that to a money judgment. So why would it be impossible?
For these circumstances, some of the property that Rodney was to, actually, all of the property that Rodney was to turn over to Debbie disappeared. She got nothing. And so proving up what these things that
The parties had placed a value on those things, you said.
well, yes.
So she would say,
I think,
we placed $10,000 of value on this personal property. None of it was returned to me. I've lost $10,000.
and I believe, I hope I'm answering your question, Your Honor. That's why these parties specified, these are what the damages will be in the event that this or this or this happens.
The trial judge didn't award damages.
The trial judge did
For-
award, I'm sorry, Your Honor.
The trial judge didn't award damages, actual damages proven for, I did not get this and I lost and reduced it to a money judgment. The trial judge said, oh, the half of the house that used to be yours, it's now hers. And there was no attempt to quantify the damages associated with the violations and that award of the other half of the community property to the enforcing spouse.
I believe, Your Honor, that the trial court here did award a money judgment.
Right.
It just utilized what the parties agreed to the value would be to come up with that money judgment.
So would that be allowed in some circumstances under 9.007A because this provision that you're relying on in the decree was made or approved in the decree of divorce or annulment, right?
Yes, Your Honor.
Okay, so if that's true, if it's in the decree that this can be changed depending on the party's conduct, then in what sense are you amending, modifying, altering, or changing the division of property that's approved in the decree by utilizing the provision that was approved in the decree?
Our position, Your Honor, is that you are not. If the trial court enforces the decree of the parties exactly as it is written, as they contemplated it, as they agreed, we believe that the trial court here enforced the decree.
Because this provision for the trial court to enforce it in this way was baked into the division of property from the beginning.
Yes, Your Honor. It was part of the mediated settlement agreement. It was part and parcel of the basis for Debbie to agree to settle at all.
Well, the provision doesn't say if there's a violation of this decree, the half of the proceeds of the sale of the home will be awarded to the enforcing spouse. The provision instead says that the court may redistribute the property in the event of a violation of this decree. So it really is not simply enforcing the decree. It is authorizing the trial court to redistribute. But 9007A says that an order to enforce is limited to an order to assist in the implementation of or to clarify a prior order and may not alter or change the substantive division of property. And so you're saying, but if the parties agree to alter that as a remedy, the trial judge may alter or change the substantive division, that's okay. That doesn't run afoul of 9.007 because they can waive that statutory provision?
I don't think they can waive the statutory provision. What I'm saying is, under these facts, that did not occur. Yes, and
Let me ask you this question. So let's say if the $500,000 that I am creating as a hypothetical is now gone, and let's say if that party doesn't have any money, there's nothing else. The only thing that's left is, let's say, a rental property that he or she was awarded in the divorce decree. But they agreed that if you don't pay the $500,000, then this rental property that you were awarded otherwise is going to go to the other party. And so if they just get a judgment, that's going to be worth nothing. It'll be like getting blood out of a turnip. But if they get that rental property, like the agreement, then that person will actually be compensated for the $500,000 that has now disappeared. Isn't that what really happens in these courts? Isn't that what really they're trying to avoid? Getting a judgment that's meaningless because everything's
Sure.
gone.
I mean, my client would prefer to have a judgment that she could enforce, that she could collect on. But it doesn't change the fact that, at least under our facts, Debbie has or had a judgment for an award of damages. There were money sitting in the registry of the court, which would have been available for part of it, but the remaining 300 and something thousand that she was awarded, she would be forced to use regular judgment collection procedures to attempt to attain those funds. We're somewhere in the middle of what happened in Brady, where there was no question but that there was a redistribution. If she did X, Y, or Z, she forfeited her trust funds. And that happened in that case, and the Fort Worth Court of Appeals upheld that. We haven't gone quite that far. It says in this decree authorizes a redistribution, but in this instance, that is not what happened, Your Honor.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Friedson and Mr. Sinclair will present argument for the respondent. Mr. Friedman will open with the first 10 minutes.
Mr. Chief Justice, Justices, may it please the court. This case is about finality and the limits of judicial power. It's about subject matter jurisdiction and plenary power that the trial court in this case...
Do you agree that the statute authorizes trial courts to enforce their judgments? And that is not a finality issue. That's just, you did not comply with my judgment, and so here are the damages associated with the failure to comply.
Yes, Your Honor, but there's a difference between an enforcement action and a modification. And in this case, we see a modification...
But this was brought as an enforcement action.
That's right, but in the substance of the pleadings, not just the original motion, an amended motion and supplemental motion, all three motions specifically requested a redistribution of property. That's a modification to the decree, not
But
an
the
enforcement.
decree includes a provision for that. So how is it a modification to the decree?
Well, there was the provision they were seeking to enforce required a redistribution. Whenever
Okay,
a
so
court,
should we just call it something, that's all you'd need to do is call it something different?
it's not about what you call the motion.
It's about what is made or approved in the decree of divorce or annulment.
It's about
And
what
so
is...
if you don't call it an amendment, modification, alteration, or change, and you say, if you don't comply, then this is what's going to happen.
Well, it's about what's pled for in the motion and what the trial court does. And in this case, the trial court did
Trial court did
reform,
exactly what the parties
modify.
agreed that the trial court could do.
Well, the power to contract stops where law begins.
Both parties agreed to it.
That's right.
It's not
but-
just one party, and they were agreeing to something that would implement what the property division was actually going to be.
That's right.
In anticipation that one person wasn't going to do what they were supposed to do.
That's right.
And that was the only way to implement it. And
Well-
so why wouldn't that be encroaching upon the finality of that agreement?
Well, if the court had enforced it in this way, according to this provision, within a certain amount of time, maybe it would have been okay. But that's not what happened here. Over a year later, the trial court then enforced it, which made it modify the property distribution.
Why?
Did you make any effort to show that the damages awarded by the trial court did not reflect actual damages sustained in connection with these violations?
No, Your Honor, because from our point of view, this case was not necessarily about the specific damages. It was about what the trial court did.
Would you agree, though, that if property valued at $50,000 disappeared, the enforcing spouse would have the entitlement to a judgment for $50,000, and that judgment could include the attachment of property that was awarded to the spouse that violated the decree?
Typically, yes, but it depends. What happened here was the final decree of divorce, and you've already said it, awarded husband 50% of the net sales proceeds of property. And then, over a year later, the trial court says, husband, you did bad. What we awarded you earlier goes to her. That's an impermissible redistribution of property. And our family code says it not once, but twice under Chapter 9. The legislature is clear. You can't modify property. That's where a court's power to enforce stops.
Can liquidated damages ever be used?
Liquidated damages could have been used, and maybe should have been used here, but that's not what the court did.
So it's really just a matter of how you write it. How would you write it for this to be enforceable?
It's about how the trial court ordered it when they enforced the motion here, when they enforced the motion.
So what should the trial court have said to make this enforceable under the decree?
Wife is awarded money damages, period.
And we're going to attach this property that's been awarded to the husband to satisfy those damages.
Well, what they did was, they said that what the money damages should be accounted for out of property he was already divided. And if
Well,
this,
isn't that the way it normally
well-
works in a civil case?
Well-
If not in a divorce case, but just in any civil case, you can attach somebody's property to satisfy a judgment.
Sure, but this is a divorce case, and we have the Texas Family Code to show trial courts where to draw the line, and it's clear.
But it's not I guess I'm having trouble seeing why Chief Justice Livingston is not right in the Fort Worth case.
If a trial court was allowed to redistribute property in this way, it equates to something like this.
Because the parties agreed to it as part of the division of property.
The contractual provision still conflicts with the Texas Family Code.
There's nothing in the family code that says that those provisions should override an agreement between the parties, nothing.
Well, the Texas courts, it's a matter of jurisdiction and plenary power. The court's ability to enforce that provision requires the trial court to redistribute property. That's in conflict with the family code.
You could say that any award of damages is redistributing property in a sense, right? I mean, you're taking property from this person and redistributing to that person.
It's how it's done, okay?
So how should it have been done?
An award of money damages, husband has to pay. However,
In
he can pay.
substance, isn't that what was done?
Well,
I just want to make sure that
Sure.
you're not advocating for some sort of magic words or form over substance thing.
I'm not advocating for magic words. I'm saying that the trial court used the wrong words here. The husband can pay those money damages however he wants.
But could we affirm it as modified then? Because we may not be able to modify a final decree, but we can modify a judgment, right? And so we use the right words?
Well, no, because the trial court issued a void order. It was void because the trial court didn't have the power to make this order.
But
Well-
going back to the very beginning, you said, oh, trial court has jurisdiction over a motion to enforce, and that's what this was. You're just contesting the relief that was afforded. It's not a jurisdictional question.
Well, again, the difference between an enforcement and a modification comes down to the jurisdiction. And so,
But if in an enforcement action, what the judge does is wrongly do something that would constitute a modification, that doesn't divest it of jurisdiction over the enforcement action. It just says the Court of Appeals should reverse it and say, no, you've got to stay within these lines. But what we have the Court of Appeals doing here is say no jurisdiction at all, despite the fact that there obviously was a need for enforcement, having, your client, at least according to the district court, seriously violated the obligations that your client agreed to in the decree, right?
Your Honor, what the 12th Court of Appeals correctly pointed out was that the trial court's order effectively modified the decree. It did not have the power to do that, therefore that judgment
That's not a
is void.
dismissal, though, is it? That's a reversal
It's
and a
vacated and
remand for doing.
dismissed because it's a void judgment. So it vacated and dismissed. And according to Texas law, that was probably the appellate court's only option here when we have a void judgment.
So
We
if
don't
there's a
look at
judgment in a
merits.
non-family law case and the judgment awards something that's beyond the power of the judge to award, do we say, turns out there was no jurisdiction over the case in the first place, case dismissed?
Not necessarily, because in this case, we're specifically looking over jurisdiction over a modification of a divorce decree, which stops after a certain amount of time as determined by the family code and Texas Rules of Civil Procedure.
So if we disagree with you about that, why is Chief Justice Livingston not right in the WLW case to say this is not a modification, it's an implementation of a stipulation that the parties bargained for and agreed to?
So the dissent in WLW, it says that
I know it's the dissent, but why is it
well,
not
the-
correct?
And we
The-
could
the
adopt that
provision-
dissent, by the way. That is not binding on us.
the provision is backward looking. In WLW, those parties' provision is backward looking. It says if the parties did something
It's not
incorrect in the
backward looking.
past-
They were thinking of that at the outset when they had entered into the agreement. And I mean, in this particular case, I think that the one party said that that person would rather property be burned than the other side get it. I mean, that they were contemplating this.
Well, the provision WLW says if in the past they had put something incorrect on if they misvalued something in the past, then we correct it in the future. In our case here, it's forward-looking. It says if there's misbehavior by a party, the court can enforce it by redistributing property.
So backward-looking would be okay, but forward-looking is not? Is that your position?
That's not what I'm saying. I was just answering the question. If it's a modification, if the trial judge modifies the provisions of property division after they lose power to do so, that's an impermissible modification.
That sounds like you're making a challenge to the contractual provision as an invalid liquidated damages provision. In other words, it's working as a penalty rather than to compensate.
Well-
But that wasn't ever addressed by the Court of Appeals because they dismissed the case.
Well, we're
So
not-
why wouldn't those kinds of contractual defenses be ones that get litigated in a motion to enforce? But that says nothing about whether the trial court has the power to enforce the provision.
Your Honor, I'd argue that they're raising the contractual defense. We're pointing out that the judge did something the judge wasn't
Right, but it
wasn't
would
allowed
be
to
your
do.
burden to show that the provision that the parties agreed to operated as a penalty and not as a true reflection of actual damages. And I think, that happens in all kinds of civil cases. And we typically don't enforce liquidated damages provisions that are outsized to the actual damages sustained. But it doesn't sound like anyone in this case is contesting that the provision as enforced doesn't reflect the actual damages.
I'm out of time. May I respond?
Yes, sir.
The contractual provision would have been okay up until a certain point when the judge then lost power to enforce it as contracted. Within 30 days, a trial court can modify a judgment, reform it. This provision it tells the trial court how that's supposed to happen. But once the trial court loses the power to modify or reform, the trial court can't follow this contractual provision any longer because it's lost the power to do it that way.
So a judgment can never have anything in it that depends on what happens in the future?
That's not what I'm saying. I'm saying that in a divorce case, after property is divided and after the court loses authority to redistribute that property division, parties cannot contract to give that court power to do so later on.
But you're ignoring the fact that it's not redistributing. They had agreed to that. This is the distribution. You get A, you get B, unless you don't turn over A, and then you get C. And that's not a redistribution. That's what they did, in Justice Livingston's words, to implement the agreement, the overall agreement.
It's literally what the trial court's order said, and that's what actually happened. They had the money sitting there. The husband's half of the net sales proceeds of the house was sitting there. And the judge says, oh, district clerk, write a check, it goes to her now. Even though a year before, the court said that half is his.
But didn't it, as it said, that half is his so long as he complies with the terms of this order? And if you don't, then it's already something that's agreed to at the beginning. It's not a new modification. I think is what Justice Lerner was getting at. Let's say the keys of the jail cell are in your own hands, right? All you had to do is comply with the order and the distribution stands. And if you don't, we've already accounted for that. That's what I think is happening here. We've accounted for the possibility that he wouldn't, and he didn't. And so then we move on to this contingency, which is part of the original decree. No redistribution, no modification, just implementation.
Would you like me to respond or just walk out? Okay. The redistribution, It's akin to saying, in a property division, husband, you're awarded your grandpa's 1953 Chevrolet Corvette. You love this car. You bought it during the marriage, so it's marital property. Later on, the parties contracted, says if either party does something bad, any property that they're awarded in the decree can go to the other side.
It's not just doing something bad, it's not complying with the terms of the court order that you agreed to,
And
right?
it's the matter of the enforcement. This wasn't enforcement, it was a modification, because it says his stuff goes to her now. And that's redefining the property division.
Thank you, Mr. Friedson. Mr. Sinclair?
Chief Justice, Justices, good morning. It's still morning. My name is Bo Sinclair, and I am also Rodney's attorney. And I'm going to try and follow up with some of the questions that I heard from you and to talk about a few things that I think are very important in this case. There is an issue here about finality of a final decree of divorce property division and how important it is. I think Your Honor pointed out that you just move property around sometimes. And I think you can in other settings. In this final decree of divorce, it said that Rodney is awarded as his sole and separate property, and then it listed things, amongst which were 50% of the sale of the house, which was in the registry of the court, and 50%, I think, it came from a bankruptcy proceeding.
Unless he didn't deliver this property that was awarded to the other party, and if he didn't, then that award of that wonderful car that meant so much to him from his grandfather goes to the other party.
I believe that that's the petitioner's position here. However, I don't think that assumes that the parties can bestow on a court jurisdiction by making such a thing. How long?
But it's not a redistribution. I mean, they've agreed to that at the very beginning, when the court clearly has jurisdiction.
Well, I believe, Your Honor, if you look at the exact context of what it says, which is recited in the 12th Court's appeal, say, may award the fair market value. It is not a one-for-one trade. It is a fact, an agreed provision that bestows. It was an agreed provision. I certainly it's agreed, but it bestowed power on a court that it cannot do.
Why wasn't that power that the court already had under 9.010 and 9.012 to reduce it to a money judgment or to hold Rodney in contempt?
Well, first of all, it did hold Rodney in contempt. I don't know if that made it into record, but second of all, they could have issued a money judgment, but the court could have issued a money judgment, but that isn't what it did. Relying on the redistribution of that, relying on the what we've been calling a damages provision, an agreed damages provision, the court did move around the assets. Specifically, it took all of the assets that Rodney had in the registry of the court, all of them.
So if the provision, if the term that the parties agreed to had not used the word redistribution, all of this would have been okay?
Well, I have thought about that, Your Honor, because I mediate cases, and this provision draws out of a mediated settlement agreement. I've thought about how that provision should have been written, and I think it should have been written in a way that you could check its implementation prior to the expiration of the trial court's plenary power.
Well,
The divorce question.
9.001 doesn't include any such limitation.
I'm sorry.
9.001 doesn't include any such time limitation.
I agree. I'm saying the plenary power of the divorce court under the divorce decree. It would have been enforceable if it had happened within 105 days, I guess, before plenary power expired in the divorce court. But once the divorce court's jurisdiction expired, all that was left is the jurisdiction that it has specifically been granted in Section 9.
So how should this have been written to be enforceable in your view under Chapter 9?
If I was a trial judge, you mean?
No, if you were the parties in this case,
If I were the
writing
party-
this to go into the as a mediator, advising the parties on how to write
I
this
would
to
have
make it
told
enforceable.
them to make sure that it had not happened, if the necessary steps had not happened prior to the expiration of the 30 days, which is the original part, to agree to file a motion for new trial, but to agree further that this would be the rendition if it was resolved by 105. I think relying on the enforcement, the jurisdiction of a court in an enforcement is very limited, okay?
So
by
in other words,
intention.
if someone is ordered to turn over property as a result of an agreement between the parties and they don't, that you're saying that the only enforcement mechanism that the non-receiving party is to start over? You just said it would be to file a motion for new trial.
Well, I didn't mean to actually have a new trial. I would have advised a series of steps, Judge, in which they could resolve the issue or have it heard by the court under its plenary jurisdiction.
So doesn't that just give the parties an incentive to just not comply with their agreement?
Well,
They
that's-
change their mind, we'll just start over.
People can do things like that, Judge.
Well,
The big
we have
issue-
pretty strong case law that says no.
The big-
Mediated settlement agreements are to be
very
enforced.
powerful, and it's very important, especially in a family law context, finality of judgment. And what this essentially does is if the court says you're allowed to contract for those kinds of things, what are the next things we're going to contract
Does there
for?
have to be any relationship between the violation and the relief afforded in the motion to enforce? So say the parties are divorced, everything's going along fine. One of the provisions is that the children shall be given to the other spouse at 6 p.m. on Sunday, and 10 years down the road, one party doesn't bring the children until 6:30 p.m. Would this judgment then attach, the same judgment?
Your Honor, I can see this in my mind. I can see if this court allows a provision to redistribute property on the Title IX or the Family Code, I can see that provision, and it says, but if one parent doesn't meet the possession and access, then we're going to, as an additional penalty, transfer some piece of property worth $1 million.
Well, certainly, there would be.
Your co-counsel said that it's a jurisdictional argument, but wouldn't it go rather to whether the provision itself is enforceable as a liquidated damages provision?
Well, I think the provision, the court relied on it and enforced it. It didn't hear damages. It didn't hear damages, a little bit of information on damages. But the court relied on it, and as a liquidated damages provision, it would be enforceable in a contract situation, but we're not in this wasn't a suit brought under contract law. It's a suit brought under Chapter 9 of the Texas Family Code.
But if the provision had said, if there's a violation of this decree, the violating spouse shall pay $2,000, not enforceable?
I think that is not enforceable. I think that
So
would be
you're
saying,
saying
unless
that the parties can't
now,
ever agree
I'm
in
sorry.
advance as to what might happen in the case of a violation?
because you are taking away the jurisdiction that's limited by the statute. The statute says you enforce the decree, and what you are doing is essentially, not you, what the parties would be doing is essentially giving the court further jurisdiction. And the jurisprudence of the state is all against that. You cannot confer jurisdiction. The only jurisdiction this court had is on the Section 9. Now,
But how would that not be enforcing the decree? Justice Bland's hypothetical, pay $2,000 if you blow past a deadline. The decree requires you to comply with the deadline. Is that not enforcing the decree?
Well, I think that, I'm sorry, I don't quite understand your hypothetical, Your Honor.
Well, I understood Justice Bland's hypothetical to be that in the decree, it says that the minor child shall be returned by 6:00 p.m. on Sunday. And if you blow past that deadline, you owe $2,000 to the other parent. That is part of the decree, and if the parent blows past the deadline and doesn't pay the $2,000, why would it not be enforcing the decree to say you owe $2,000?
Well, it would be enforcing the decree, but it wouldn't be enforcing property division. That would be something that would be possible, I think, under the statutes that
So if
provide.
it says
for
that the
possession.
$2,000 shall come from this particular pot of fungible money that you can just put into your bank account, then that's a disaster. But if it's just $2,000, however you can come by it, enforcing a decree.
You could enforce a decree under the other provisions of the family code. I think if the parties are allowed to confer jurisdiction beyond what's in.
If we send this back
Chapter 9.
and say it's okay as long as the district judge says that the money can be paid from any source of money that your client has,
Yes.
no problem.
Yes, and the district judge has many ways of enforcing that. In fact, specifically, Chapter 9 calls out a judgment. It says a judgment, and it's very specific in what it says. And this court could have granted a judgment. I'm sorry, I'm almost out of time. May I finish answering the question?
You may.
Okay? This court could have granted a judgment, but it did not. It didn't do it. And so the decree is everything that that court did was beyond its jurisdiction.
But just to make very clear, the answer to my last question, if we send this back and say, yep, you did it wrong, but it's okay to do the exact same thing so long as the judgment of the same exact amount must be paid from any source of funds available to your client, that is okay.
I think the court could have done that.
And we can do that now. We
but
can send
did
it back
not.
for that purpose.
I think this court can send it back, perhaps to the 12th to see if there's any other issues, or even to the trial court if it so sees fit for any reason, is my understanding. But I think the court should not. It is void. The judgment was void. The statute of limitations have long since run. This is a harsh remedy for the petitioner. I understand that. However, they took it down the trial court proceeding the way it went. And I'd ask the court to affirm the 12th court. It provides a bright line rule.
Any further questions? Thank you, Mr. Sinclair.
Thank you.
Ms. Wright, you have 5 minutes.
Thank you, Your Honor.
Let me ask you about we talked about the vehicle, the Mustang, that was the hypothetical. Let's say both the husband and the wife, it's priceless, it can't be reduced to money. And they agree in the divorce decree that husband's going to have it, but if he doesn't deliver the children as promised in the visitation portions of the decree, then she gets the Mustang. Is that enforceable?
I think the parties can agree to that, and if they agree to it, I think the court can enforce it.
So what if they agree, if he doesn't deliver the children as promised in the decree, that we're going to come back in here and do a whole nother redistribution because we've got to think about this differently if he's not going to comply?
I don't think that it's a good idea to put in place something that reopens a reevaluation. And I don't think that's what happened here.
Could you do that? Could you have an agreement? We're gonna have a hearing and redistribute a bunch of property if there's a violation of the decree?
I'm not sure under the state of our statutes, you could.
Chapter 9 seems to only address property division, right? So would that, if you're making it contingent on what happens with the kids, is that property division?
That's kind of where my quandary is, Your Honor, is I think the issues that we have to do with property and property damages, and I don't think you really ought to tie, and maybe it's not an ought to or not ought to, but it doesn't seem to be on the same lines as this case if you're talking about what's happening to kids versus what's,
Well,
just
let's
like
not get hung up on the breach that's causing us to come and have an action for enforcement. The decree says the Mustang is going to go from you to you if X happens. Is that enforceable as a contract, or is that a redistribution of property that's
I think it's
prohibited?
both. I wouldn't, I think it is enforceable under our statutory enforcement scheme. I think that it is authorized if the parties agree to it. Now, I don't think you could come back in hindsight, you get a divorce, something happens with property, and there aren't these provisions in place to come back and say, well, he didn't give me this money, so give me spousal maintenance instead. I don't think that you can do that. But if the parties agree to something and incorporate it in their decree, I think it can be enforced just like the other provisions in there are enforceable. And I also believe, if I might address something that opposing counsels have said here, that this would have been okay if it had been rendered sooner. And the contractual provision would have been okay, except they lost the power to modify or reform. And it would have been enforceable if it had been completed in 105 days. I think the record is clear for this court. This might have been able to be completed in 105 days, but for the fact that after the enforcement proceedings were begun, Rodney filed motion after motion after motion with the administrative judge to try to get rid of visiting Judge Lauren Parrish. And when that didn't work, he sought a mandamus to do it. And when that didn't work, he went back down to the trial court and filed the same motions again. And so there was a significant period of delay. We might have been able to finish this in 105 days. But the sole reason why we didn't get there lies on the respondent, who here is trying to say, well, you know, it's a harsh remedy. But it's like a king's X here. That should not be the...
Is there any question that the funds from the registry that were awarded to your client approximate the value of the property that was not turned over in the first place?
I'm sorry, Your Honor.
Yeah.
Can you repeat that?
Is there a question, in the question, in the hypothetical about a $2,000 award for returning the child late, we have a disconnect because we don't really have evidence of what is the penalty or what is the actual damage. There's no way to damage returning a child late, right? Here we have property that was not turned over. Does the record tell us the value of that property? In other words, could the Court of Appeals relied on the record to conclusively show that the value of what the wife did not receive, what that value is?
Your Honor, I'm out of time. May I respond? Not exactly, Your Honor, and here's why it's important that there was a liquidated damages provision. Rodney destroyed portions of the marital residence, had it flooded. He made inaccurate and untrue claims that the shop had suffered EPA spills, reducing the value. None of the personal property which was to be turned over to Debbie did she receive. And some of those damages, particularly that related to the real properties, I don't know how you would have estimated what's the damage for a fraudulent EPA claim. What's the damage to the marital residence because a VA person seeking a VA loan can't get a VA loan for that property, and so it has to be a cash sale now. I don't think, to try to directly answer your question, that the record contains specific evidence of actual damages, and I think that's why this was put in place.
Any further questions?
Thank you, Your
Thank
Honor.
you. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.